Lesson: Key Principles of the GDPR and U.S. Privacy Comparisons. Understanding the key principles of the General Data Protection Regulation and their comparison with U.S. privacy laws offers significant insight into how businesses can navigate the complex landscape of international data protection and cross-border data transfers. The GDPR, enacted by the European Union in 2018, represents a comprehensive framework that establishes strict guidelines for data protection, emphasizing individual privacy rights and organizational accountability. In contrast, the U.S. approach to privacy is more sector-specific and less centralized, creating a patchwork of regulations that businesses must navigate. The GDPR is built upon several principal tenets: lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. These principles serve as a foundation for data protection practices and guide organizations in their compliance efforts. Lawfulness, fairness, and transparency require that personal data be processed legally and ethically, with clear communication to data subjects about how their information will be used. Purpose limitation mandates that data be collected for specified, explicit, and legitimate purposes, and not further processed in a manner incompatible with those purposes. Data minimization necessitates that only data necessary for the intended purpose is collected, ensuring organizations do not retain excessive information. Accuracy is another core principle, obligating organizations to keep personal data up to date and rectify inaccuracies promptly. Storage limitation requires that data be kept in a form that permits identification of data subjects for no longer than necessary. Integrity and confidentiality emphasize the need for appropriate security measures to protect personal data against unauthorized or unlawful processing and accidental loss. Lastly, accountability compels organizations to demonstrate compliance with these principles, often through documentation and implementation of data protection measures. U.S. privacy laws, such as the California Consumer Privacy Act and the Health Insurance Portability and Accountability Act, reflect a more fragmented approach. The CCPA, for instance, grants California residents specific rights regarding their personal data, including the right to know, delete, and opt out of the sale of their information. However, unlike the GDPR, the CCPA applies only to certain businesses meeting specific criteria, and its scope is limited to California residents. HIPAA, on the other hand, focuses on the protection of health information, highlighting the sectoral nature of U.S. privacy regulations. The differences between the GDPR and U.S. privacy laws present challenges for organizations operating across borders. For instance, the GDPR's extraterritorial reach means that any company processing the personal data of EU residents must comply with its provisions, regardless of where the company is located. This can create compliance burdens for U.S.-based companies that must align their practices with both GDPR and domestic laws. One practical tool for navigating these complexities is the Data Protection Impact Assessment, a GDPR requirement for processing activities that pose a high risk to individuals' rights and freedoms. A DPIA helps organizations systematically analyze their data processing activities, assess risks, and implement measures to mitigate them. This tool not only aids in GDPR compliance, but also fosters a culture of privacy by design, where data protection is integrated into the development of products and services from the outset. Another effective framework is the privacy by design approach, which encourages organizations to embed privacy considerations into their operational processes. This concept, while rooted in the GDPR, can be adapted to various regulatory environments, including the U.S. PBD involves principles such as proactive, not reactive measures, privacy as the default setting, and end-to-end security. By adopting PBD, organizations can enhance their privacy posture and build consumer trust. Case studies illustrate the importance of these principles and tools. For example, the British Airways data breach in 2018, which resulted in a significant GDPR fine, underscores the necessity of robust security measures and accountability. The breach exposed the personal data of approximately 500,000 customers, highlighting the repercussions of insufficient data protection practices. In contrast, A company like Microsoft has successfully navigated GDPR compliance by implementing comprehensive privacy measures and transparency practices, which have become a competitive advantage in the global market. The adoption of binding corporate rules is another strategy for organizations engaged in cross-border data transfers. BCRs are internal rules adopted by multinational companies to ensure that personal data transferred outside the EU is adequately protected. This mechanism not only facilitates compliance with GDPR, but also provides a framework for consistent data protection practices across jurisdictions. Statistics further emphasize the importance of these principles. According to a 2020 survey by the International Association of Privacy Professionals, 74% of organizations reported that GDPR compliance had improved their data security practices, and 51% noted enhanced customer trust. These figures demonstrate the tangible benefits of robust data protection measures. In conclusion, understanding and implementing the key principles of the GDPR while navigating the complexities of U.S. privacy laws is crucial for organizations operating in a global context. Tools such as DPIAs, the Privacy by Design framework, and binding corporate rules offer practical solutions for compliance and risk management. By adopting these measures, organizations can not only meet regulatory requirements, but also foster a culture of trust and transparency, ultimately enhancing their reputation and competitiveness in the marketplace.